Good evening and welcome to the Civil Service Commission of January 10, 2018. I will be acting as the chair. Mr. Manoukian, Commissioner Manoukian had an emergency and won't be able to make it. Could we have a roll call, please?
Commissioner Devine?
Here.
Commissioner McCarley?
Here.
Vice Chair Abkarian?
Here.
For the record, Chair Manoukian and Commissioner Gazarian are absent.
Next, please.
Minutes for the meeting of December 13, 2017.
I move for approval without changes.
Second.
Move in second, pass unanimously. Next.
Oral communications.
I don't see any cards. Next.
Recruitment and examination report.
Mr. Doyle.
Mr. Chair, members of the Commission, this is our monthly recruitment and examination workload report. This report contains current recruitment activity amongst the staff. Once again, seems like things never slow down, kind of a busy time of the year. And what we're seeing is tend to have a lot of retirements toward the end of the calendar year. So we're now commencing recruitments to fill a lot of those positions. And then looks like we have a listing of various of our park and recreation hourly positions, which we start recruiting for now, some for the summer camps and aquatics programs. We try to start early and do that now. And then we have our usual allotment of police officer recruit positions. In fact, this weekend we'll be doing our joint written exam, physical agility exam, both Saturday and Sunday with large groups of candidates. So anyway, with that, it looks like we have a total of about 60 processes at various steps, and this is a note and file item. If you have any questions, I'd be happy to try and answer them for you.
Any questions? What's next?
For the record, Commissioner Gazarian has arrived. Eligible list established.
Mr. Doyle.
Mr. Chair, members of the Commission, this is a report on our eligible lists that have been established since our last meeting. A little lower number than you're probably used to, but this probably has to do with since our last meeting we had the latter part of the December with all the holidays and then New Year's, and so kind of difficult to schedule exams, tests, and interviews during this time of the year. But nevertheless, we do have six lists that have been established. They all happen to be internal promotional processes. They're there before you. If you have questions, be happy to answer them for you. If you have anything, please let me know. Otherwise, this too is a note and file.
Thank you, Mr. Doyle. Any questions? Okay, what's next?
Reorganization of the Commission.
Mr. Chair, members of the Commission, once a year the Commission will select a new chair and chairperson, and it's been exactly 1 year since Chair Manoukian was named chairman and Vice Chair Abkarian was made vice chair. So at this point, it would be appropriate for the commissioners to go ahead and nominate and recommend candidates for chair and vice chair.
A point of order, please, if I may. I believe Commissioner Manoukian assumed his post in June or sometime not in the beginning of the year, and at that time we spoke about having a person serve a full 12-month period before reorganization. If I'm mistaken, I stand corrected, but that's my recollection, because I don't think Chair Manoukian has been the chair for a year.
Actually, let me just make a correction. What had happened was, because of continuous delays, he actually wasn't appointed until January of 2017.
Oh, is that when he was appointed?
Yeah,
because
he was supposed to be appointed in May, and then he was delayed for so long that you actually mentioned, listen, 6 months has passed, he's only going to be serving only 6 more months until June of 2017.
Okay, so he has been the chair for a year?
Yes.
All right, then I stand corrected, if that's the case.
Chair,
if that's not the case, I don't want to shortchange it.
Chair, members of the Commission, that is my recollection as well, that previous Commissioner Devine served something close to a year and a half. Again, we would normally do this process in May or June of each year. I think it's been June, and for various reasons, the appointment in 2016 kept getting pushed back, and finally, Chair Manukian assumed the chairmanship, I believe it was January of 2017. So
Then
he has served a year.
that's
Mr. Chair,
Yes.
I'd like to nominate Commissioner Abkarian for chair.
I'll second that.
Okay. Can we have a roll call, please?
We would ask Commissioner Abkarian, we would ask for other nominations, and then we would do a roll call vote.
Okay, any further nominations? Okay, now we can do roll call.
Commissioner Devine,
Yes.
Commissioner Kazarian,
Yes.
Commissioner McCarley,
Yes.
Vice Chair Abkarian.
Yes. Thank you. Fellow commissioners, I appreciate it. I would like to pass the gavel down and nominate Mark McCarley for vice chair.
Second.
Any other nominations? Roll call.
Commissioner Devine,
Yes.
Commissioner Kazarian,
Yes.
Chair Abkarian,
Yes.
Commissioner McCarley.
Yes.
Thank you. Again, thank you very much to my fellow commissioners. I appreciate it. And now we move to the next item.
Review of civil service rules and regulations and discussion of potential amendments.
Let's do it.
Mr. Chair, members of the commission, a few months ago, the commission directed staff to revisit our civil service rules and regulations. These are the rules that govern civil service for the city of Glendale. The direction was to bring the rules forward for review and any potential changes or amendments for discussion for this group. We have done that. Over the past few months, staff came up with a total of 9 items that these are things that we've thought about, discussed over the past few years since our last revision of these rules, mainly related to efficiency and improving some of our hiring processes and procedures. It's not a terribly exhaustive list, but I think it's a good starting point. The commission was also encouraged to submit any ideas of their own that they may have. As the report does indicate, Commissioner Abkarian did spend a good amount of time reviewing the rules and came up with some recommendations for consideration. And I do want to commend Commissioner Abkarian for going through this exercise. It was a lot of work and a lot of thought went into it. And we do appreciate the ideas that he put forth. In addition to that, Commissioner Abkarian did meet with myself and Ms. Varpetian in December just to go over some of his recommendations and mainly to get clarification. And I think it was a beneficial process for both staff and Commissioner Abkarian as far as the final outcome of what he's submitting as recommendations. So tonight we do have a series of potential amendments, again, coming both from staff and Commissioner Abkarian respectively. By way of review, again, Article 24 of the City Charter authorizes the establishment of civil service rules which govern our civil service system in Glendale and sets general parameters for our employment practices relating to the hiring, employment, and retention of city employees who are covered by civil service protections. The Charter provides essentially the framework, and really it's the Commission's job, along with staff, to fill in the specifics and adopt rules that will achieve the objectives of civil service and good governance. In coming up with rule amendments, at least from the standpoint of staff, it was our intent to look for ways to improve the process, maintain fairness and general precepts of civil service, but also to look for ways of working smarter and more efficiently. I don't think the concept of working smarter and more efficiently necessarily runs counter to our civil service principles, but some may disagree with that. But the bottom line is, since the last update of the rules, the organization has undergone some significant change. We've had significant staff reductions from staffing levels of close to 2,000 full-time salaried employees to a number closer to 1,500. So it's essentially a reduction in our organization by almost 0.25%. In doing so, we've had to adapt to some changing needs and try to be more flexible in our efforts to hire and retain qualified candidates. Additionally, the commission now meets only once per month, and this was a change that took effect in August of 2016. It used to be twice a month, and I think it was a good change for the most part, at least for everyone's schedules, your schedules, staff schedule. But there are actions that occasionally do require commission approval that we don't necessarily want to delay. So some of the recommendations, at least being put forth by staff, are relooking at some of the items that are coming before the commission and questioning whether or not we want to continue having that occur. As I said, we have amendments submitted both by staff and by the commission, and at this point, I guess we can open the discussion as far as how you'd want to proceed with this. I do want to make it clear, and we do have representatives of our employee associations here. Once again, reiterate, any changes to these rules are subject to meet and confer with our employee bargaining units. It's required under the law, and once again we have direction from the commission on any changes, I am then obligated to meet with these folks. And it's not only lawful, but it's an appropriate thing, because these rules are in essence there for them. So with that, I'll turn it over to you, Mr. Chair, however you'd like to proceed.
Commissioner Kazarian had a question.
I have a quick clarification question. Mr. Doyle, you stated that, and I did review this package, and I did note the extensive work done by Chair Abkarian, and I'm thankful for from him. You mentioned that these potential amendments for consideration, if I understood you correctly, were also worked on, or input was taken from Chair Abkarian. Is that correct?
Not the ones that came from staff.
I see. The ones that I have that are numbered 1 through 9 are those
From the staff directly.
I see. Those are not. So I would be incorrect in assuming that you would be voting in the affirmative as to 1 through 9, because you haven't really had input with that, correct?
Correct. I have comments about 1 through 9, and some
as do I.
I am not in favor of.
And I think the process will show that I am not in favor of some of them as well, absent some clarifications. All right. Having said that, before we proceed with these rules, I'd like to make another clarification request and a comment. I note that in the memo to us on page 8, the very last paragraph for my fellow commissioners, it states that even though the rule amendments are approved and adopted by the Commission and City Council, any proposed changes to the rules are subject to meet and confer provisions, which I believe you just alluded to, Mr. Doyle. Am I to understand then that any proposed changes that this body approves will then be the subject of discussion in the course and scope of a meet and confer? Or has a meet and confer occurred as to all of this and everybody's on board?
Commissioner Kazarian, it's the former. Essentially, what we're looking for tonight is general direction from the Commission. If there are ideas, either those amongst those submitted by staff or Commissioner Abkarian, if there's some general direction to pursue those ideas, those concepts, those amendments, then we would be obligated to meet and confer with all 5 of our employee bargaining units prior to a final decision being
So
made.
let me be careful so that I am not argumentative, because that's not my intention. It seems to me that if we were to now agree with some or agree with all, and then the meet and confer produces the word I hate, disgruntled bodies within the city, this exercise would be what then, a waste of time, or how would you then address those concerns at that time?
These are items that must lawfully be bargained over. And
see.
what I would do, my thought would be to engage in the meet and confer after getting direction from the commission, and then coming back to the commission and reporting on that.
I see.
And if there are some changes that the commission really wants to see that may not have a favorable reaction by our bargaining units, then I would report that to you, and you could then decide whether it's worth going, providing me the further direction to continue bargaining. But the idea is that we should try to come to agreement on these matters, and hopefully the commission will be receptive to our bargaining units. As I said earlier, these are rules amendments that are provided for their protection, and believe me, they understand these rules very well, and they're not going to be shy about letting us know what they support and what they don't support.
So this is not final?
That's correct.
What we decided
Yeah.
on is not final?
In
Let me
an
just,
ideal circumstance, I would see direction tonight, and if we get through all these tonight, which I don't know if we're going to, but and then we would engage in the meet and confer, and then I would bring this item back, and then if there is general agreement on certain of these amendments, then we could vote upon those, have you vote upon those, and then bring them before City Council.
If I may make my comment.
Of course,
and
please.
I'll be
Please
through.
finish, I'm sorry.
My comment deals with the review of the 9 potential amendments. Correct. More so than all the other material that has been inputted by Chair Abkarian. As to the 9, I note that in the memo, it says, and you stated it on the record this evening, that in August, the commission switched from meeting twice monthly to once per month, and that now appears to be given as a reason, if not the reason, that when potential for certain actions which require commission approval are being delayed because we meet once a month, that is a basis or a ground, a reason for some of these changes. And I want to say this, and I think, well, I'll speak for myself. That rule, that change occurred, as I recall very well, not because anybody on this body didn't want to meet twice a month. It was because primarily the agenda items were thin, generally, more so than had been in the past. And second, we all were in agreement that if there was a need to have a meeting more frequently than once a month, that one would be scheduled so that this body fulfills its duty to the civil service employees of the city. So I do not want there be any misunderstanding that because we meet once a month and it's for our convenience, that some of the oversight that this body is entrusted with is now going to be divorcing itself from and leave civil service employees with the perception that this body is not overseeing that which they believe they have a right to, and by law I believe they do have a right to. So that with that I'm ready to proceed.
If I could respond, Commissioner
Sure.
Gazarian, I completely agree with everything you said, and certainly not hanging my hat on this once a month argument in order to effectuate these changes.
Okay. All right.
I am merely pointing out, and it doesn't happen often, but there are some items that do need timely approvals, and because we're only meeting once a month, it could happen that we may fall short of that. And the amendments that staff is proposing that relate to that particular item, it's mainly items 1 and 2. There's other rationale for that. Really, it's not the fact that we're only meeting once a month, but as set forth in that exhibit, there are other reasons that would argue for those particular amendments. But everything you said was completely true. This meeting once a month was not any desire by the commission to lessen its workload or anything like that. It was correct. We were having very light agendas for some period of time, and many of the meetings were being canceled, and it made sense to do it once a month. So anyway, I agree with what you're saying, and when we get to those items, we can discuss the merits of it.
Mr. Chair, if I could kindly adopt Mr. Gazarian's comments, I think they were focused. And to extend a bit your comment, as I read the charter, at the end of the day, this commission, in fact, enacts the rules and regulations for our employees within this city. And as a result, we bear a very heavy responsibility. It's an interesting comment as we think about this and as we read the charter, whether indeed there's, quite frankly, any review by City Council or any other agency of what we both propose and what we adopt. And I think that relates to the structure of the Civil Service Commission as the charter was enacted almost a century ago. So this is a very critical proceeding. With that said, I would ask our chair to outline a procedural posture for the conduct of what I see as a study session with each one of these proposals put to us with comments solicited from each of the members. And Mr. Chair, to the extent that we have the time to solicit comments from our employee associations, it'd almost be sequential, 1, 2, 3, and 4.
Yeah, let me just clarify this, maybe if Mr. Devine doesn't have any comments before we actually go into them. A few comments, if you don't mind. First, I think that the amendment, as Mr. Doyle mentioned, to the Civil Service Commission rule plays one role and one role only, is to ensure that there is a fair hiring process and a process for appeal to Civil Service Commission by employees. I don't know how there'll be a lot of conflict. I mean, I'm sure there'll be some comments made on the rules, but our job is to make that happen, to make the process as fair as possible for employees of City of Glendale to be able to obtain jobs and to be able to appeal if they feel that the job that they're getting is not being given to them unfairly due to discrimination or whatever reasoning there might be. So for that, again, my comment is to say that of course we need input from the employee associations because they are the front line of the employees and they need to give comments so we can actually incorporate those comments because we're not on the front line. We are just a body selected by the City Council, and accordingly input from the employee association is crucial to what we do. With that in mind, let me just make sure that we understand the process. Today is a study session of us basically telling you that these are the ones that we consider to be important and we would like to get those move forward. Then there'll be a study session, then there'll be a discussion with all employee association and you will extract their comments. There'll be another meeting, I would say the main meeting, where we would then come in and vote on all of these items one by one and get the entire package passed. That package then goes to the City Council for their approval and then will become the new rules and regulation for the City Council, for the Civil Service Commission. That's the process. And the process does include going to the Employee Association. Today is the day that we make our comments and suggestions as to what we believe are important to this body here. Now, the next process is to go to the Employee Association after we finish this study session. So with that, my suggestion would be that we will go over some of the comments that I made and we go through each page, so to speak. I know it takes longer, but trust me, this is important. And we go through each page, and then when we get to the comments made by the staff, then we'll review those as well and see if we want to vote for it or vote it down.
You mean you don't don't want to do 1 through 9 first? I thought that was the
You want to do
sequence.
that? If whatever is, it's easier for the commission. If you want to do 1 through 9 first, and then we can go through the rest of the stuff, I don't have any problems with that. Whatever is easier for my commission.
I would suggest that we do 1 through 9. and
Okay,
then,
let's do
I
that then.
agree with that.
Then let's do that.
I was geared and prepared to get that out of the
If
way
you-
if possible.
Commissioner Gazarian, if you're geared towards that, then that's exactly what we'll do.
I'm
So,
seldom geared, but I am now, yes.
okay, let's do Rule 4, Section 3C, pages 13 and 14. Mr. Doyle.
Mr. Chair, members of the commission, this, for lack of a better term, we'll call this amendment number 1 or staff number 1, however you want to refer. This would essentially no longer require commission approval of job bulletins when it's proposed that a bulletin switch from promotional to open. As you know, currently, any bulletins that come before you where it was previously recruited for on a promotional basis, meaning in-house only, if the department is requesting to go to the outside, all of those are required to come before the commission for their approval. There may be cases where you know, the employee associations have no comment or have no concern, and I think what the amendment is to state that the staff would be required to notify the associations of the city's intent to go from promotional to open, and only if the association or bargaining unit objects to that we bring this before the commission. But if there's no objection, that it proceed in order to open. So that's. I'm proposing a change, but I'm also, I believe, providing a safeguard for the associations that require some consultation. If you know, and if they don't care, then it doesn't come before you.
Commissioner McCall.
I could defer to my senior here, and then I'll follow you,
Commissioner
sir.
Gazarian.
Thank you, Commissioner. I wrote no on the right column when I read this, and I'll tell you why, and maybe you can change my thinking. I don't know. When I saw switch from promotional to open, I envisioned, here we have a job bulletin, it's promotional, that means those within the city can apply for it and seek the promotion. And then at some point, a decision would be made that we would have no knowledge of or no oversight, and it would then switch to open, and then lo and behold, someone can come and say, wait a minute, you know, I believe I'm qualified for that, I should have been promoted. I'm encouraged by the fact that, you know, there's language in here that says the bulletin only require commission approval if the employee bargaining unit objects to the bulletin switching from promotional to open. But then I end up writing on the margin saying checks and balances question mark. How am I going to know? I, as someone who's entrusted to have a fiduciary duty to the civil service employees of the city, how am I supposed to then know that that entity that protects that employee's rights did object or did not object, A, and B, whether or not that union did or did not object, what about the individual employee's right to come before this body and say, look, what happened to that promotional just got switched to open, and I was discarded or disregarded. So those are my concerns.
Mr. McCauley, Commissioner McCauley, and then Commissioner Devine.
Thank you, Mr. Chair. Once again, I'm in complete concurrence with my fellow commissioner, Commissioner Gazarian. My concern, of course, and what I will say will be my concern throughout the tenure of my service here on the commission is, in fact, the manner in which class specifications, this is a technical term used in the section itself, Rule 4, Section 3, subparagraph C, which is what the staff is seeking to amend. And for us, I believe it is our one of our most significant responsibilities to carefully scrutinize class specifications, translated into job descriptions, job requirements, essential work functions, everything that's associated with that job. And if the transition is from promotional to open, which is the suggestion here, once again, we should have that opportunity to scrutinize. The amount of the work effort will be minimal. We process these reviews at the rate of a couple every 3 or 4 minutes at the commencement of each one of our meetings. My argument is amplified by the fact that staff has indicated in its justification for the rule that our fine employee associations must be consulted. I 100% concur. If our employee associations are consulted, their input sought, they'll contribute that input not only at the staff level, but they are invited and encouraged to come here and articulate to the commission. So I say that the value associated with this amendment is far less than the effort put into making the amendment. Frankly, I would keep the existing Section 3, subparagraph C.
Commissioner Devine.
Okay, first, I'd like to clarify, Mr. Doyle, when we switch from a promotional to an open, does that preclude a promotional employee from taking the exam?
Commissioner Devine, no. They can apply as an open candidate and compete equally with those candidates who don't work for the city.
So going from a promotional to open really just expands the cadre of people that could apply for the position. Is that correct?
That's correct.
And again, the promotional people in the city at this time would have every opportunity to compete against anyone else taking the exam.
That's correct.
Okay. As far as this
But
proposal,
again, Commissioner Devine, just so I understand, then the competition could be between 10 people with promotional compared to 100 people going to the open. So it does affect the person who is in promotional.
well, I agree. I agree with that, but it also gives the city an opportunity to make sure they get the best candidate,
And they
whether
still
it's
can.
whether it's in-house or outside.
You're right. You're 100%.
So, there's two sides to that sword. One, it does create an impediment for a promotional if there's only 2 or 3 versus
Correct, you're right.
open with 10 people, but it helps the city make sure we're getting the best people to work for the city.
I'm sorry, and to piggyback on Commissioner Devine's remark, that being said, that almost begs the suggestion that every job opening should be an open opening, not promotional, because after all, we'll have much more larger pool for candidates for the city. If that's the case, then what are we talking about here? There must be, and at least you, Commissioner Devine, are far more experienced in this area than I am. You've been here a lot longer than I. And I've seen you be a champion for employee rights. So perhaps you can tell me what is the value in promotional that at some point it loses its value and it's okay for it to go to open without commission oversight, and I'll be comfortable. But otherwise, that argument is a great argument. The best employee for the city is the best employee for the city, and I, as a city resident, welcome that. But then what does that mean for someone who is in a city department who aspires to promote, who now doesn't really have a benefit of loyalty to the city by being a city employee, because he or she is on equal footing with someone coming from 200 miles away applying for the same position.
Let me make sure that we all are on the same page. This is not saying that we should have promotional or not. This only says that the promotion being turned into open, what the staff is asking is staff approves it, and what the current rule says is that it has to come in front of commission. That's it, right?
That's correct, yeah.
Okay, so I just want to make sure that we don't get off the road in here in a different direction. It's either commission approves it or staff approves it, and the current says commission, and the staff suggests that on those that are not opposed by the employee association, that the staff approves it. And so go ahead, Commissioner Devine, I'm sorry.
And I have to say that Commissioner Gazarian brings up a good point. There's really no argument. It could go either way, and we could debate that for an hour, but I don't think that's what we're here for. That being said, I agree with Commissioner Gazarian and Commissioner McCarley that this should be a no, that we shouldn't do that. But to me, the key in this was that it does eliminate the employee's opportunity to decide or voice his concern whether it should be open or promotional. And to me, that was the whole crux of this, and why I would say, no, we shouldn't impose this rule. And so that's where I stand.
Okay. And I think that I made my comment is very clear, that I am in favor of the amount of time that it takes for us to approve a promotional to an open is anywhere between 3 to 15 minutes. And I think that our meetings usually take about 15 to 30 minutes. We can set aside that just to ensure that there are checks and balances. So I would say that I would like to take that particular one out. Accordingly, from what I'm hearing is that rule number 1 will be not moving forward with rule number 1. Do we need to take a vote on that?
That's interesting, Mr. Chair. Again,
Hold
going
on,
back.
let me hear
Yeah,
from
that's
from
true.
our
That would
attorney.
be appropriate.
No, you would not need a vote on that. I think we're taking your direction. The only thing I would caution you is that when we meet and confer with the employee associations, they may have their own opinions as to some additional rule amendments, and I'm certain that the commission would be open to hearing what those comments are. So when we sit down with them, and this is an item that they'd like to discuss, I think your direction is that we should hear their comments on it.
Of course. But understanding that we made our comments and they know what direction we're kind of
Correct.
tilting on this. And again, I think that everyone agrees that this is for the protection of the employees of the city of Glendale and nothing else. Our focus is just that, to ensure that the employees are protected. Okay, so what's next, Mr. Doyle?
That you did raise an issue, Mr. Chair, and that is whether or not we should take action and as a study committee, sort of in the same vein as a subcommittee to a Congress proposing or reviewing a set of proposed legislation. We're going through this. We could take this off the table, no longer a matter of conversation or consideration.
Which we
did.
The only thing that would come would be if the employee associations feel so strongly about this that they would like to bring it back at some point.
And that would
Our
be
direction
absolutely
right now to the staff is that this should not be a recommendation from the staff.
I would suggest, subject,
Correct.
of course, to input. I think we got input from our legal advisor, is that I'll make a motion that it be taken off for consideration.
I said we don't need a
No
motion.
formal actions necessary. You're giving direction to staff. We're making notes. We heard
Just
you.
amongst us, do we have concurrence that it comes off?
And I think I've
I
already
see a
mentioned that.
consensus among
Four,
us.
that's fine.
Yeah, I think I mentioned that we are taking that out. The staff is not to bring that up unless if there's some desire by the employee association to bring this back. Mr. Dole, what's next?
Next, similar item having to do with commission approval of job bulletins. And right now, any job bulletin that gets posted what we call safety promotional is brought before the commission and for their approval. And again, in a similar vein, this would recommend that this no longer be required. That unless staff is going to deviate somehow from either the approved class specification or from the previous selection process. Given how the commission felt about the previous one, I'm pretty certain I know how you'll feel about this one. So,
Yeah. Do we have consensus that we can take this out?
Well, I would suggest withdrawal.
Okay, so number 2 is out. Mr. Dole, next.
Next would be Amendment 3, having to do with examination appeals. And this is one of the areas that we're looking at. And this would be to essentially shorten the examination appeal period following the completion of an exam. Currently, when an exam is finished, whether that's a written exam or practical exam or even an oral interview panel, at the conclusion of the day, the candidates, or actually when they come in for whatever exam, they're notified both verbally and in writing of their rights to appeal any portion of that exam, if they determine that it's either unfair or not job-related or some type of a inappropriate question or inquiry is made. Right now, they have 3 business days in order to make that determination and notify staff at the end of the 3rd business day. And what occurs is once the exam is completed, basically staff sort of freezes the process. We don't provide results until that 3-day period is completed. And ultimately, once any appeals or other concerns that are raised are resolved, again, we give them 3 days to do that. And once all of those are resolved, then we release the exam results. And again, the idea is that if a candidate leaves an examination or an interview or whatever the case may be, and they have some type of a concern over some degree of unfairness in that exam, or if an inappropriate question was asked or something like that, that they're going to generally know that right after they leave. So staff is questioning the need for that period to be three business days. Oftentimes when we finish an exam and, whether it's a captain's exam or a fire captain or whatever, we have the candidates who are very, very anxious to get the results, and they're calling us the very next day. And typically we have to tell them, no, it's going to wait. It's got to wait till the 4th day before we're able to release it. So what we're proposing is instead of being 3 full business days, that it be something less than that in order to facilitate some efficiency here.
Okay, having gone through the civil service process numerous times and very familiar with this rule, I would be opposed to changing it from 3 days to 1 day. Mr. Doyle brings up a point that right after the exam, you probably know if there's some irregularity that you want to talk about, but along with that process, you like to talk to other people. You like to talk with your peers or whoever before you make a final decision on whether or not you're going to appeal. So I think that cushion of the 3 days is very important for the employee to be able to have, and I would be opposed to that change.
Thank you. Yeah, I wrote no because I was thinking to myself, and I don't want to be disrespectful. I was thinking to myself, really? I mean, you want to reduce the 3 days to 1 or 2 days? What if somebody really wants to think about it? They want to think about it because when you reduce it, I dare say you're going to get more complaints than those who may have had time to reflect and perhaps not complain. It can work both ways. And to suggest that we need to rush it so that people are anxious to get a result, I felt like if this was a negotiation, and it isn't, I would say, okay, you know what, I want it to be 5 days. You want to reduce it, I want to extend it. But I don't think that it needs to be extended, but I think 72 hours is eminently reasonable. A person may one day be distraught, the second day they may gather themselves, and on the 3rd day they may file a grievance if they want to. I think it ought to remain as it is.
Mr. Chair, I'm always one who is interested in the data, and for data I will turn to our director. Chief Examiner, I think, is your technical title.
That's me.
Chief Examiner. And do we have data on the number of examination protests, let's say, within the last year or fiscal year for Glendale?
Commissioner
Every
McCarley,
exam, somebody surfaces and says that there's a question in that examination which is inappropriate. Is this a real problem, or is this a conceptual problem?
We don't have data, and as far as is this a real problem, frankly, we don't get a lot of appeals. Number one, I think we put together pretty good exams. We know how to word things.
Congratulations to you, by the way. Yeah. Excellent work.
And to assure the commission, we do, as I said earlier, advise all candidates of their rights, both verbally and in writing. They have to actually sign something with the understanding that if they have a concern about the exam, they can bring forth, contact the department. So I would say when we do a written exam for a position like fire engineer or fire captain or police sergeant or something along those lines, we will get a number of inquiries about certain questions. You know, there might be a multiple choice exam with 120 questions, and we'll get, you know, we'll have a few of the candidates come in and say, hey, you know, I think there might be multiple answers to this one question. Will you look at that? Okay. I mean, does that count as an appeal? Yeah, we accept it as an appeal. And typically what we'll do is we'll review that, and we'll either make the determination that, hey, it's a valid protest and we'll modify that, or no, we're going to hold to the key on that exam, and we'll get back to them. So that's the most common. I don't have specific data on that.
I fully appreciate that.
Oral boards, hardly ever. Hardly ever.
Anything?
Just real quickly, I think you get the tenor of the committee. And equally, if there's a consumption of time, Mr. Doyle, I think that consumption of time would occur if, in fact, somebody aggressively pursued an appeal of that examination, because the following paragraphs in that regulation allow and direct you to appoint a board or a review and investigatory board, and then after that board responds, the aggrieved applicant can apply here. That could take months. So we're dealing with 3 days. That's insignificant in comparison to 6 months to a year that this regulation allows.
And again, not to belabor the point, but that's kind of the point of the recommendation. This hardly ever happens, and you know, making people wait 3 days. Okay, maybe it's not a big deal, but you know, we like to move on to the next one. So,
okay. I think you know, anything else?
No, thank you,
Yeah,
Mr. Chair.
from my side, I couldn't say it any better than Commissioner Kazarian said it. My concern on this one is that if we put it on 24 hours, people who are not going to file an appeal will just file it just to protect their rights, to be able to file an appeal, and then think about it later and say, wait a minute, well, maybe I don't want to file the appeal now. But because we gave them 24 hours and they have to react within those 24 hours, the number of appeals will actually increase instead of actually decreasing, because now somebody that comes next day says, wait, I better file the appeal, and then if I decide I want to withdraw it, I'll withdraw it. So my concern is that, and I don't think 3 days is that long. Whoever can't wait 72 hours, you know, that's a bit of an issue. So I think, again, just hearing from my fellow commissioners, and again, we've heard from all four minus Commissioners Manukian, it's not here, is that item will actually come off, and the staff, we do not want staff to make that recommendation. Is that correct?
Correct.
From everyone? Okay, so number 3 is out. Number 4, Mr. Doyle?
Okay. Members of the commission, number 4 has to do with probationary period extensions, and this is what I would call a clarification. We've had, well, as you know, the commission rules allow for the extension of probationary periods, and there's a process that's done where, you know, a department will contact Human Resources and ask for additional time if they need additional time. It kind of flies in the face, however, of the charter, which states that probationary periods shall not exceed 12 months. Now, we have 6-month probationary periods and 12-month probationary periods. And the legal interpretation we've had from our city attorney's office is that due to the charter provision, probationary periods cannot ever exceed 12 months. And so I thought it would be helpful to clarify that in the rules, to indicate that really this rule, as far as extending probationary periods, really only applies to those with 6-month probationary periods. If a department can't make up its mind after 12 months, then then we probably have other problems. So this is more of a clarification, and I wouldn't anticipate this being controversial.
Chair, in about 30 seconds.
Mr. Commissioner
Thank you,
Carr.
Mr. Chair. I would absolutely concur with our chief examiner. This is consistency with the charter. I brought a portion of the charter here to amplify what you've said, and we must do that. We're in legal jeopardy if we do not.
Okay, thank you. Anyone else?
I have a question. The question is, does the city charter, I want it to be consistent with city charter. That's what I have. I have nothing contrary to the city charter is my note on this item. My question is, if anyone knows, and perhaps you would, Mr. Doyle, when we say that the city charter indicates that probationary periods may not exceed 12 months, I'd like to know, does the city charter permit for that 12-month duration to be extended due to leave of absence or placement on modified duty?
Commissioner Gazarian, it does not address that. The charter
The charter does not address
does
that.
not address that. We've had legal opinions by our city attorney's office going back to Scott Howard, 2 city attorneys ago, who have opined that if there is a leave of absence, you can add that on to any probationary period, whether it's 6 months or 12 months. But it would just not be logical to say, to not include that provision. Otherwise, someone could start at a job, have some type of catastrophic illness for 11 months, and oh, surprise, they get to pass probation, and that's not clearly what the intent was of the charter language. So.
Yet, yeah, I agree with what the intent must have been. I'm troubled by the fact that if the actual language is probationary periods may not exceed 12 months, I would have thought that the drafters of the charter would have added 1 or 2 words, may not exceed 12 months of employment or 12 months of active employment, versus leaving it vague, because a strict constructionist would read that to say 12 months. 12 months is 12 months. So if the person is sick, 6 of those 12 months, so you got 6 months to evaluate them, I suppose. But as long as we here enact or amend our civil service rules to mirror that of the city charter and not be more than the city charter in terms of latitude, I'm comfortable. Yet I'm not sure if we will be able to do that, because I'm now hearing that the city charter doesn't really specify that. So what I would be comfortable with is that it ought to be 12 months at a maximum. So that position that is a 6-month probationary period obviously can extend to 12 months because the person is ill or they're on leave of absence. But the person that is on a 12-month probationary period, I want a department to be able to have 12 months of actual probationary employment of someone. But if it was leave of absence, it's one thing. But placement on modified duty, that phrase troubles me. Placement on modified duty by whom? So the department can then say, I'm going to place you on modified duty in an effort to extend the probationary period of a person who would otherwise have successfully, or at least calendar-wise, completed the probationary period, and the buck would stop with that probationary period conclusion. That's my concern. Placed on modified duty, placed by whom? Leave of absence is different, because that's somebody taking a leave of absence. I don't want that person to get away with having been not scrutinized for 12 months on a probationary basis. So that's food for thought.
Let me just clarify one thing. What you said is very interesting. I didn't even consider that, but the probationary employee that is intentionally put on a modified duty, let's say, even though they're during the probation, does that employee have a right to appeal that decision? Because at that point, they're not civil service
Of course not.
employees, so they don't have any right to appeal to civil service.
They would
right?
not. They're at-will employees at that point. And I think the point is good to
Thank
include the modified duty thing, but the modified duty instance is only done when someone is injured. And, you know, we have a choice of either sending them home on sick leave or if it's workers' compensation or something like that. But if they're placed on modified duty, the city can at least get some work out of them, and there tends to be a speedier recovery we've seen when people are placed on modified duty versus sent home to recuperate. But the bottom line is when they're on modified duty, they're not doing the job that they were hired to do. So it's if we want 12 months of experience observing an employee performing the work of a police officer, we want 12 months in that job.
That's
6 months in that job and 5 months or 6 months as a dispatcher, or 6 months working at the front desk because they have a broken leg or something like that. So it's only fair to the employer to enable them to have the full snapshot of that time period to assess their ability to do that job.
Let me just say, could we say that we would like this to be, we would like to approve this minus a discussion with the city attorney's office to ensure that the legality of this compared to the city charter?
Well, the city charter does not address, from what I understand, Chair Abkarian, does not address extension of any period of time for any reason beyond 12 months. It doesn't address it. It's silent. So it's subject to interpretation, correct?
That's correct. It says, sir, I'll read it to you. The commission shall adopt rules providing for a probationary period, for a period of probation not exceeding 12 months before appointments or promotions are made complete.
Right. So to take your example, which was one in my mind, a probationary police officer is not just a police officer who's on patrol. There are many duties that a police officer performs, including police report writing, doing investigative things of sorts that doesn't require him or her to be behind a wheel or in a black and white or on a motorcycle on the streets. There are many ways to get maximum observation out of a probationary police officer that are not exclusive or limited to placing that individual on the field, although on the field is a critical component of that role of the police officer. I'm troubled, I'm encouraged and troubled. I'm encouraged when you say we only place people on modified duty when they are injured. In the instance where a medical professional deems a particular civil service employee, a police officer, a probationary police officer, injured, and places them on limited duty, I suppose that may mean desk duty or a disability of such nature that that person is useless for purposes of employment and therefore they're home.
Commissioner Kazarian.
Yeah.
Let's clarify that now.
Yeah.
Could the manager put someone on light duty without a medical necessity?
No, in my 30 years around here, this place, I've never seen that occur. There has to be a medical reason, and in fact, we are obligated to address that. You know, if it's a disability or some type of an accommodation like that, there'd be no reason to do that. If you know, a manager had some ulterior motive to try to mess with someone, they could simply fail them on probation. I couldn't see any rationale for them deciding, well, let's put them on modified duty and make them sit for a while in a different assignment. It just doesn't make any sense. What will occur occasionally, and we see it in fire, we see it in police, is someone who gets injured while they're on probation, and you know, if they cannot perform the essential functions of that job, you know, and you know, they're either placed on a desk or put up in dispatch, answering calls or something like that. You know, we're not seeing their ability to do the job, and I know there are other types of sworn assignments that officers can do, but when an officer on probation, my sense is that they want to see how they perform as a patrol officer out in the field. And we have some cops here who might be able to articulate that better than I, but
I think I may I have a question that may resolve mine and perhaps others' concerns, if any. When we say, when our materials here are saying on top of page 12, thus, it would be beneficial to clarify this point within the rules, as staff often receives requests to extend 12-month probationary periods. So if a 12-month probationary period is extended and staff receives a request, does that come to the Civil Service Commission for that extension?
no.
If you make that come to the Civil Service Commission, then I could say, okay, that extension of the 12-month is now has checks and balances. But if you're suggesting that a 12-month probationary period can then, without civil service oversight, cause that person who has no civil service protection because they're a probationary employee remain for a longer period of time without that protection that they would otherwise have had vested in their 1 year of investment as a probationary employee, that's troublesome.
Here's the,
If I could just, I'm sorry, if I could just address your point with regard to the language that's in the charter. The charter, section 2 of Article 24, sets forth certain responsibilities that must be covered in the rules. Certainly, it's not an all-encompassing section. It cannot include every possible scenario, and so therefore what the charter mandates is that the commission adopt rules, and that's where those come in here. So I think the goal is to provide for, in the rules, the circumstances under which the probationary period may be extended or may not be extended. So in this particular instance, what I think Mr. Doyle is saying is that if there's no reason, for example, medical reason being a good reason because you haven't had an opportunity to evaluate, then under those circumstances, in his discretion, he may provide that extension because he's also received the validation from the city attorney's office that the rules would provide for that. But I think what he wants to make sure is that those reasons are in the rules and they're clear, and so that therefore when he provides a denial, that's not questioned.
and I appreciate city attorney's comments, because when you read the last two sentences or the last two lines of that of the staff report, this happens. I get erroneous requests from departments. Hey, so-and-so, I'm not sure if we want to pass him yet. Can we extend it? And if it's a person on a 1-year probation, the answer is always no, I cannot. It's per the charter, and it causes confusion. So that's when I say this is sort of a clarification. I get that. Maybe 2-3 times a year, people who erroneously believe that they might be able to have a little more time. Now, if it's a 6-month probation, not a problem. Typically, I'll question them. Why do you need to, and that sort of thing. But when it comes to 12 months, I really have no discretion there, unless, of course, we have a person out on leave or on some type of an extended modified duty where we haven't had the ability to evaluate them for 12 months. So
We provided. Oh, I'm sorry.
Go ahead.
We provided our director with ample discretion, however, in the rules that are presently enacted. Now, those rules on their face are inconsistent with a charter provision. And if we say that the charter provision controls, then when we look at Rule 6, which allows Rule 6, Section 2, subparagraph 5, that says that upon a written request from an authorizing, approving authority, appointing authority, that would be one of the directors within our proud city,
right.
and that director asks for an extension, you are authorized to grant that extension of probation. So you're right to bring forth that tenuous legal area that you found yourself in when you're trying to comply with the charter, but yet earlier members of this commission years and years ago provided you with the opportunity to extend. So at this point, I guess what we're seeking is, do you want us to give you that legal confidence and say, okay, you are not authorized to extend beyond 12 months, period? And that would be facially consistent with the charter.
Commissioner McCarley, my proposal is just really to clarify. There's a section which you cited that addresses, the requested extension of probationary period, and what's not listed there is that this whole notion that, anyone on a 12-month probation cannot have their probationary period extended, and that's what I wanted to see in print, just so I don't get the request and have to explain it
So
over and over again.
let me just piggyback on what you just said.
Yep.
We can have a hybrid where we can say no one could go past 12 months unless if they bring that request to Civil Service Commission.
I would agree with that.
And would that be consistent with the
No, the commission does not have the authority
But-
to extend beyond
12
the charter.
months, right?
The charter does not allow even the commission to do that.
Now, that's
So-
interesting because if in fact, as we addressed earlier, that we are the rule makers, then in effect, we would be in violation of the
of the
charter.
charter?
Right.
100% violation of the charter.
Yeah.
Okay, I personally, and I'm sorry.
No, that's fine. The net result, if we didn't see the language, the proposed rule and regulation language changes, but for the intent that you've inserted in the paragraph, I guess what you're saying is to just take out section 2, subsection 5, or subsection F, just take the whole thing out, because that would be the net result of what we're proposing to do.
That is not, Commissioner McCarley, because there are, if someone is on a 6-month probationary
Okay, I
period,
understand, but cannot,
I wanna have them
or
to-
we add that it cannot go beyond
cannot
12
exceed
months.
12 months, yes.
12 months, subject to some exceptions such as modified,
Leaves
as
or
they say,
modified.
temporary modified duty based upon recognizable medical issues and/or leave, disability leave or military leave, something like that.
That's correct.
I'd like to hear from Commissioner Devine.
Well, being surrounded by 4 learned attorneys, this was highly technical for me.
You probably know a whole lot less than
I feel about your opinion, so I'd like to hear from you.
You probably have a much better opinion than attorneys would do,
Well,
I
I
promise
was
you.
looking at it from a very simplistic standpoint, and what I understood was that Mr. Doyle wants to change the rules to comply with the charter. We just spent 30 or 40 minutes going around and around figuring that out, but bottom line for me is I think he should be able to change the rules so it will comply with the charter, end of story.
Okay, everyone agree?
Yes.
I agree.
Okay,
Comply with the charter is.
okay, number four is agreed by all the Civil Service Commissioners
Wow,
unanimously.
we got one, huh?
We got one out of 4 so far, Mr. Doyle.
It took work, Mr.
It's
Doyle,
gonna get
Chief
harder.
Examiner.
What's next, Mr. Doyle?
Okay. Number 5. This is found in Rule 10. This is the section which deals largely with disciplinary actions. And it has to do with placement of employees on administrative leave. And as the Commission is aware that we occasionally have to place employees on administrative leave if they're facing some type of investigation or disciplinary proceeding. And the proposal would be, the current language indicates that these ordered leaves of absence with pay shall be for up to 30 days. And the practice, the policy has been that if it needs to exceed that, which it almost always does, that we have to essentially extend it continually. And the recommendation would be to eliminate that language that refers to 30 days. And I certainly understand probably the intent of the 30-day limitation, which has been in there for many, many years. And I think our intent is always to avoid having these administrative leave instances go on and on and on for months and months and months. However, the reality is that if we're going to place someone on administrative leave due to some type of an egregious policy violation, it takes time for staff to investigate those allegations, to complete that process. Sometimes the investigation takes different twists and turns, and then when that investigation is complete, a report has to be written, and it's typically reviewed and gone over by a city attorney's office, and then ultimately, after the investigation report is completed, we have to decide what method of disciplinary action, if appropriate. All of that takes time, typically much longer than 30 days. So my request is to simply take out that language and enable staff to exercise due diligence in these disciplinary investigations.
Commissioner Duane.
Okay. Again, looking at it very simplistically, I agree that it sometimes takes more than 30 days to resolve an issue. I would be in favor of this, but with the condition that a new time limit is set. And I would rely on staff to tell us if 30 days typically is not enough, what from your experience is a good number? 40 days, 60 days? But to give staff a carte blanche to have them on leave for forever, I don't think is a good position. So I would be in favor of this, provided we get a number from staff that would solve their problem and yet not giving them a carte blanche to do it forever.
That's where I'm sorry.
Oh, go ahead.
That's where I was at. I put no if indefinite, must have a finite duration, because when you take it out, I mean, first of all, when there's no deadline, there's a tendency to take your time. It's human nature. And it's really not fair to someone who's on administrative leave to be on administrative leave without knowing that, look, I know according to this rule and that rule, I'm gonna get a call telling me come back, don't come back, whatever. I will go along with the simplistic way of Commissioner Devine's approach, so long as there's a reasonable finite time. Otherwise, I would say no. If it's going to go beyond 30 days, then they ought to seek that extension beyond 30 days.
Well, I always subscribe to the philosophy, if it ain't broken, don't try to fix it, because I'm looking at Rule 10, and there are two areas in which that rule focuses. First is suspension without pay. We're not addressing suspension without pay. That relates to egregious conduct on the part of employees, which basically mandates that they be removed. And then there are, as we've discussed, ordered leaves of absence with pay. And that particular provision provides for 30 days of pay, and it gives discretion to the department head, which would be the appointing authority, to move forward and extend that period of ordered leave with pay. I would think that in recognition of both employee rights and the discretion given to our department heads, that particular provision be preserved. It allows for the careful and measured decision on the part of the department head as to whether this particular employee should or should not remain. And ultimately, that decision can be at least appealed up to the city manager. Now, it could be that if you want a further level of appeal, if, for instance, our employee associations want to be assured that this is not completely arbitrary, we could, as perhaps suggested by you, if it's quite detailed, we could leave the opportunity for the disgruntled employee or an employee who was put on extended leave without pay to come here and say that somehow they've suffered significantly because they've been left without compensation, and an investigation has gone on for 1.5 years, and their department head has basically said nothing.
I'm sorry, this is with compensation.
Yeah, with compensation. Okay. What I'm suggesting is right now you have the tools necessary to accommodate both the interest of your department heads and the employees. So why change it?
All I'm saying is these investigations, if something's serious enough to warrant somebody being placed on administrative leave, we're talking serious stuff, sexual harassment or assault or theft or something like that.
Alleged.
Absolutely. It's not the investigation, the resolution of that, the due process action is not going to be resolved in 30 days. And just to clarify, the due process portion of it, the pre-disciplinary appeal process, when someone is served with what's known as a Skelly letter, they have the right to appeal to both the department head and plead their case, have their attorneys come and all that. And they have then following that, they have the right to appeal to the city manager's office as well. All that occurs before this even comes to the commission. So that process
So,
alone,
I don't mean to cut you off.
I'm just saying 30 days.
No, I understand. What I'm hearing from the fellow commissioners is that they don't have a problem with moving the 30 days to a different number. They just want a number.
Yeah, I'd like a number. I would feel much more comfortable. Short of a number, I am very uncomfortable.
Just to be clear, I mean, you talk about numbers. I think several of the commissioners are well aware of the Peace Officer Bill of Rights, which gives up to a year from the initiation of an investigation to the completion of that. I mean, that's how long sometimes these things take. So I don't want to, I guess I'm not asking for carte blanche, but something realistic that recognizes the severity of these situations. So whatever you're comfortable with, but I would argue on the high side.
Okay, let me just say this. You have to go to the employee associations to discuss this with employee associations. Could you please talk to each one of them, give them our concern, and come back with a number that would be, so I would say we will approve condition on a number that the Civil Service Commission would consider to be reasonable.
Sure. Yes, I agree with that, Chair Carey. And there are some Bill of Rights for some certain classes of civil service employees, but I am unaware of other Bill of Rights for other class of civil service employees. And this does not seem to be specific as to a particular class of civil service employees, i.e. police officers. This seems to be all civil service employees. So that is why I'm a bit uncomfortable. I'm fully aware of the other Bill of Rights you cited. My concern is the other 1,000 or so employees in the city.
I think the direction is, so we can move to the next one. The direction is that we would approve number 5, condition on a number that would be reasonable when you bring it back to us in the future, that we believe would be a reasonable number that everyone would have some benchmark to go with, correct?
Less than a year is what I would personally hope to see.
Mr. Chair, I just want to add one comment. I would certainly second your directive, because as chair you have that authority, you do, to ask the chief examiner to go forth and engage our employee associations for their input. This is perhaps one of the most important regulatory changes that we've been presented this evening, because it affects an individual employee who perhaps wrongfully was put on administrative leave and is without compensation for what you are now telling us. No, but could be if on the 30 days and there are no extensions. See, under the present provisions in this set of regulations, 30 days, you get 30 days, it's over. As we have been instructed by our director, the administrative disciplinary process could go on for a year, perhaps longer. And we have multiple instances before that. So we need that type of input. I'm just suggesting that I want input before we make any decision.
All right, so I think Matt is pretty clear as to where we need to go on number 5. It's an okay with condition on the deadline. Matt, what's next?
Okay, this is in the same section, and this one is very, very important to staff, and this has to do with sort of the limited nature of what currently is provided for ordered leaves of absence with pay. There's a couple of very specific instances where it is allowed, and what I'm proposing, or what the staff is proposing, is that this language be made a little broader to address not just disciplinary separations, because typically when somebody is being disciplined and terminated, they will remain on administrative leave for the duration of that with the pre-disciplinary Skelly process. But I'm suggesting that this be broadened for other reasons of involuntary separation, specifically layoffs. If we give someone a layoff letter and say that, here it is, it's October 1st, effective November 1st, you're hereby laid off from employment, that the department have the opportunity to place that person on administrative leave. Right now, the rules are silent on that, and the problem is, similar to someone who's being fired, you don't necessarily want them to be in the workplace. Someone who's being given a layoff notice, more often than not, it's not a good idea to have them continue to be in the workplace. They could be disruptive, they could be angry, they could be upset, they could commit acts of sabotage, they could slip and fall and get an injury as they're going out the door. We've had actual instances of people just refusing to work, where they say, screw the city, I'm not going to do anything for the next 30 days. And it's been quite disruptive. It doesn't happen a lot, but when this has happened, it's been quite a problem for those departments. So my recommendation would be that in those cases where it's an involuntary separation, that the department be given the opportunity to place someone on administrative leave with pay till the duration of that separation.
So my question then is, because I wrote down pay question mark.
Right.
If somebody is involuntarily separated, meaning laid off,
Correct.
do they get the same amount of money, or do they get less money versus if they were placed on administrative leave?
They get the same amount of money until the date of their separation, till the date of the layoff.
Okay, so if an individual is determined to be laid off come March 1st or February 1st, you're suggesting that you be given a blessing, if you will, to put them on administrative leave with pay as of tomorrow.
Correct.
So then they would continue to receive their full salary, but then does that then convert to a layoff less salary on February 1st?
I'm not following your question.
No, they're laid off. They
They're
get
laid off
nothing.
with nothing. They get nothing.
They get
They
zero.
get nothing.
I see.
Unless
So,
there's a severance agreement of
I
some
see.
sort or anything like that.
okay. So if you want to lay somebody off, is there a rule that you have to abide by to give them notice, I'm laying you off starting 2 weeks from now? Or you could just lay them off the same day?
We can, but there's increasing case law that suggests that you should give notice, and also there's an obligation to meet and confer with the respective employees association over the impact of that layoff. So it's not, the decision to lay off is not subject to meet and confer, but the impacts or the effects of the layoff are, and sometimes that process of meet and confer might take a couple of weeks or a month or whatever the case may be. So
So my understanding is, you're saying, once you lay off that person, you give them a notice, in 30 days you're gone. You want to have the opportunity to tell that person, go home, we don't want you to do any work, we'll still pay you for 30 days until
correct.
you're laid off on February 1st.
that's correct.
Okay.
That's
I got it.
I don't know. I have great difficulty with that. As you've indicated, this is significant. It certainly does not take place in the institutions from the federal perspective where I spend a considerable amount of time. When there's a layoff, and you work until such time as there is a layoff or a furlough with the expectation of perhaps rehire when sufficient funding becomes available. So I suppose the only gain that I have derived from the conversation is that when an employee is given a layoff notice, a 30-day layoff notice, that somehow that employee becomes so disgruntled and demoralized that they're no longer effective as an employee, so therefore it's better to send them home than to retain them in the workforce. I'm not necessarily sure that that's supported by anything other than perhaps anecdotal evidence, if that.
That's
It just seems
exactly what I'm suggesting, and that's exactly what I've experienced. In my 29 years here, I've been part of probably 5 or 6 layoffs, and this is exactly what happens.
What happens when people are laid off, the 5 or 6 layoffs that you spoke of just now? Are you suggesting that none of them ever are brought back?
Sure, of course. No, we have brought back, we have reinstated people following layoffs.
Yeah, I remember that.
But that occurs when there's either work for them to do or
Okay.
there's funding for them to do work. But why do we lay people off? Because we don't have the work, we don't have the funding, we have to make budget cuts, whatever the case may be. When and if that gets restored, everyone who gets laid off, they get separated from employment, they get put on an eligibility list,
Yes.
and maybe 6 months later, a year later, things get better, and we have the ability to hire some people back.
But
We go back to that list and reinstate those folks.
But Mr. Doyle, wouldn't the person, if I was going to be laid off and I loved my job, I want to come back, I would have every incentive that the remaining 2-3 weeks before you lay me off, you've given me notice, to show you that perhaps you laying me off was the wrong decision, and in fact, I'm indispensable. Why are we suggesting that they're going to be unruly and therefore we should pay them and not get anything in return for the city?
Number one, Commissioner Gazarian, that's your feeling, and that's you. Not everyone thinks the way you do.
Well, I hope people think that they.
Well,
May I make a, can I
I'm
make a
basing
comment
this-
on this?
I'm
Because I feel
basing this on
strongly about this.
experience.
Okay.
And what I'm saying is, we don't have to do this.
No,
We
I
don't
understand.
have to.
I
But if
understand.
we have a concern of, again, sabotage, disgruntlement, fake injury, well, you can shake your head, but these
we've
things
had
happen.
Hold on.
These things happen.
Let me make a quick comment, if you don't mind. I worked in a large firm where, unfortunately, I was put in to let go of some people in my position. And in a private practice, you let them go, and 10 minutes later, you walk with them to their desk to make sure that they're not sabotaging the computers, put everything in a box, and walk with them downstairs with the security. Unfortunately, that's the reality of life. When you lay off someone, the possibility of that person being disruptive is reality. It's not fantasy. It's something that happens, and unfortunately, maybe the military doesn't have it, but it is the civil servant. There are personalities that take that very negatively, and they could really have a very negative effect on the actual workplace. So I personally do not have any issues whatsoever with this particular change. I think it's necessary. For me, to be very honest with you, I would say within 24 hours after they're let go, that's a good enough notice, but I come from private sector. So when you give them notice and you're going to pay them, it's like a severance pay during the 4 weeks or 3 weeks that you let them go while you're paying them. They can be looking for another job. They can do whatever else they want. Again, I'm saying my personal opinion, I don't have any problems with this rule whatsoever. I think it's a necessary rule to keep peace in the workplace, plain and simple. And I don't have any problems with it myself. Yes?
And as much as I would like to concur and generate a consensus, I do have a reservation, because I think the justification that we've been presented, that somehow our employees, the employees who have supported and made this city what it is today, would somehow become disgruntled, amateur saboteurs, would no longer be productive. That is, quite frankly, an interesting.
Well, that's not what they're saying. They're saying
Well, that's-
there could be occasions, and there has been occasions, where employees have been disgruntled. They're not saying everyone who's laid off is going to be disgruntled. And it probably 98% or 99% people are not. But that 1% that causes problems, the chief examiner should have the right at that point to have a leave of absence with pay, which is what they get anyways in 3 weeks when they're laid off on February 1st.
But not that we are not the comptrollers for the city of Glendale, but there is an expense associated with this, because we pay for those folks who are proud employees of this city for the contributions that they make in a variety of fields, from police to public works to accounting, everything that they do on a day-to-day basis that make this city, once again, one of the greatest places to live. I don't see it. My experience far beyond anecdotal, and I will say it once again, when I had to effect a furlough at the federal level, and we had 1,000 people we never saw an instance of sabotage or a type of employee that did anything that would reflect poorly on that employee. This is a very unusual provision. when you use the term layoff, that suggests that there are economic realities in this city. Hopefully, we don't experience what we experienced in 2010 when we had to go through that layoff. But it does indicate that it's a no-fault issue that the employee is let go because the city doesn't have sufficient resources. I would suggest the greater threat is when you terminate somebody for cause. That's that individual that you're going to need to escort and watch very, very carefully. I think from a fiduciary standpoint, from a fiscal standpoint, from what it says about our employees, that somehow we're now painting them as folks who will not do the right thing and work until the end. I can't support this.
I think that, let's not mischaracterize. I think that the request is to have the authority that if somebody is being disruptive, to be able to give. I don't think that the agreement is that every employee is going to be disgruntled once they're laid off. Commissioner Gazarian.
Yeah, there's one word. If that word wasn't there, I would be comfortable with the direction that you have, Chair Upcarry, and that word is any. Any. It says any. Consideration of an amendment which would enable the placement of an employee being involuntarily separated from employment for any reason. What other reasons are there? I mean, you're either laid off or your disciplinary proceedings have been instituted.
This is true.
That's it, right?
Maybe that word was a little careless.
Yeah, so if that word could be somehow reworded and taken out so it doesn't appear like, well, here's another reason we're going to give now because we decided that this particular job requires you to be 6'9" and you're only 6'1". I don't know. That any is.
Well, why don't we go ahead and enumerate exactly what it would take to do it, and then bring that back to us again, so then we.
But I did not hear from Commissioner Devine.
I agree with Commissioner Abkarian.
There you go. I heard it now. Thank you.
So you got one nay vote.
Yeah, I think we vote up, taking the any reasons, and I agree with that's a little bit too broad. Maybe we enumerate, when you're meeting with the employee association, maybe you enumerate exactly what those items are and take any reasons out. And then it would be more specific as to what we're talking about.
And if Commissioner Devine on the next item can tell me where you are, it will probably, because
Okay,
your
so let's,
opinion, that means much.
do we want to go ahead and just take a vote on this one? Because
Number 7.
Why don't we go ahead and take a roll call on this one?
Thank you.
Number six.
What is the motion that we're?
The motion is that we approve it with taking any reasons out and enumerate exactly what we're talking about, layoffs.
Yeah, and since we're not actually wordsmithing, we will certainly take that word out when presenting the information to the associations.
That's it.
Yeah, so I don't think that you need a
So when it
formal
comes
vote.
back-
Because there's one nay, I want to go ahead and take a roll call, just to make sure that the record is clear, so 6 months down the road, somebody doesn't come and say, well, I said nay, you never ever took a vote on it. So let's go ahead and take a roll call, just to make sure that the record is clear.
And the motion is that.
There's no motion. What we're voting on is
Study
Rule number 6, Rule 10, Section 3A. Move forward, and could the,
Right.
could
okay.
Matt actually
So
take
no
that?
actual, no formal motion, because you
No.
don't have a motion in a second.
I just wanna
But the
make sure-
sentiments from each commissioner as to whether or not it should move forward or not.
Right, would it move forward or not? So let's take a roll on that.
Commissioner Devine?
Yes.
Commissioner Gazarian?
Yes, subject to the limitation of the word any.
Commissioner McCarley?
No.
Chair Abkarian?
Yes. Okay, what's next? Okay, let's get through this in a few.
Number 7, this relates to disciplinary hearing procedures for our sworn firefighters. I think several of you, well, 2 of you were on the commission in 2014 when we incorporated the provisions of the Firefighter Procedural Bill of Rights into our hearing procedures for employees who are sworn firefighters and their disciplinary action. And this is part of the government code, and really it's not something that we were able to modify or anything like that. It's a law, and the biggest provision of this Firefighter Bill of Rights involved the inclusion of an administrative law judge to preside over and serve as counsel to the commission when we have hearings relating to sworn firefighters. And again, the commission, actually, we spent a couple of meetings sort of wordsmithing the language, and this is actually the procedure is attached as Exhibit 3, and all I'm proposing is that we incorporate this into the rules, and I think the simplest way to do it would be to attach it as a separate addendum or appendix at the end of the
Where's the exhibit?
I don't know if it's attached or not.
I didn't see any exhibits.
Yeah, it should be starting on page 65. I'm sorry, 66. It's right after and it's Exhibit 3. It's right
I see it.
after the whole.
Next time, if you can put an exhibit number in the bottom. it'll
Oh,
make
there
that
it is
a
on
lot
the
easier.
top, yeah, I see.
We can't see an exhibit all the way on top on the right side when there's staples going in. So
Okay.
if it's all the way in the bottom from now on, it would be great. Or separate piece of paper that says Exhibit 3, like in the bottom, it would be great.
Commissioner Devine, please.
Well, I think basically it's a ministerial act that, we got to put it in there. My main concern is, what are the duties of an administrative law judge as it relates to this commission?
Thank you.
I've read this over and over again. I've seen several definitions, but I really don't know what role a ALJ will play on our commission hearings. Does that person have a vote? Does that person,
No,
no?
that person will not have a vote. They would actually rule on admissibility of evidence and number of other issues, but they will not actually vote on the actual commission decision at the end of the decision.
So it begs the question, why isn't it the same for a police officer?
It wasn't.
I'm
Yeah, the
sorry?
Peace Officer Bill of Rights, which has been around
Does not
since the
include it.
70s, does not include this provision. It's really odd, but when the firefighters got around to writing their Bill of Rights, I think it was made law in 2009, 2010, something like that. They tried to mimic pretty much everything in the Peace Officer Bill of Rights, and except for
But here's the issue. Forgive me. The real issue is when you say that I don't know which one of us said that the administrative law judge rules on admissibility.
I read it's firefighters.
So having sat on a number of disciplinary hearings here with counsel to the hearing body, the counsel to the hearing body makes recommendations whether or not to admit or disallow certain testimony or documentary evidence. But in the end, the chair of that particular hearing body makes the decision to admit or disallow testimony. If we are now speaking of this in such a way where an outside hired person who happens to be an administrative law judge sits in, it kind of turns us into jurors as opposed to hearing officers. And I'm not sure if that is sufficient for protection of the of the firefighters. But though you say it is in their Bill of Rights,
You don't have a choice. I read the Bill of Rights
Okay.
very carefully. I thought this was crazy, but when I read it, it says what it says. It says the administrative law judge has to be there. The administrative law judge will make decisions as to admissibility of evidence. It's very clear. It says it right there. However, it also says that and I did some research, anyone that has 5 years of state bar admissions could actually apply and be appointed as an administrative law judge.
as to that hearing.
As to that hearing specifically. So you could be appointed as an administrative law judge if you've had at least 5 years. And then, again, there are 2 other conditions which I think 3 commissioners in this body actually meet very easily. So if you can apply and be appointed as an administrative law judge, then you actually, the chairperson could be the administrative law judge in that hearing as appointed.
or the Commission's counsel.
The Commission's counsel could actually apply, and the Commission's counsel could be the administrative.
I see. So it's not an administrative law judge that happens to be on
That
a
is
panel of
correct. It says,
administrative law
it says
judges.
that the that the body could actually request, and an administrative law judge could be appointed that has the following requirements, and they give you the 3 requirements right there on the Police Bill of Rights, because I'm assuming that they assume that there won't be a huge amount of administrative law judges going all over the place. So our attorney could be actually, could apply, become the administrative law judge, and then rule on admissibility of evidence like they would do anyways in
Well,
our
that was
cases.
another question I had. What's the difference between the duties of our current attorney on the panel than a LJ?
Well, the
it sounds
difference would be that the administrative law judge could overrule the civil service request to actually admit a particular evidence in.
Well, it's the other way around.
Let me indicate something. I've had experience with this. The administrative, I would adopt, Mr. Gazarian, exactly what you said. What we will become, in effect, are jurors. Very similar to a construct, it's sort of a court-martial construct, where you have an administrative judge, happens to be called a judge. According to the rules for those assemblies, that judge makes decisions, evidentiary decisions, admissibility of evidence, that sort of thing. Procedural questions are resolved, and then the ultimate decision, the decision-making authority, is vested in the jurors or the members of this commission. Right. The only difference between a jury, as the 3 of us are familiar with juries, and what we would do as commissioners is we would be allowed the opportunity to engage in examination or cross-examination subject to the approval or disapproval by the administrative law judge. But as Mr. Devine indicated, we've got no choice here.
Yeah, there's no choice.
This is one of those in which I said
Chair
put
Perry.
it in there because we can't get around it.
Chair Perry, the rules already exist in the form of the hearing rules. The recommendation is just to incorporate it within the rules proper. So
Just for the
there's no
firefighters we're talking about,
change
just let's make sure that we're.
That's correct.
to process.
Well,
No comparable
along that
precision.
line, I get back to my original statement that, it's going to happen.
Yes.
But what are the specific duties of the judge? Now, I've heard, the 3 of the attorneys talking, they have different thoughts and ideas on
Oh, no,
it.
it's specifically noted in the firefighters' Bill of Rights, what the judge will make all evidentiary decisions. That's what it says specifically.
Okay,
And I suspect it would,
In one place, it says he presides over the hearing.
Right,
In
it
other
does.
words, so
Serve
does
as
that mean
counsel.
he's the chair?
Yeah. He's the chair of the council, makes decisions on evidentiary evidence that comes in, and allows you to ask questions.
Yeah.
But the ultimate decisions, technically, I guess, in reference to can you ask questions or not, it also resides with the administrative law judge.
Well, what about the ultimate decision?
The Civil Service Commission makes the ultimate
Yes.
decision.
We vote on it like judges.
and let's go back to the specifics that are outlined in the hearing rules that are referenced here, and I think no one received a copy of the exhibit, so perhaps we can.
did.
We did.
It's
But you were saying you didn't?
Yeah, it's hard
Okay,
to find.
so you did receive it?
Yeah.
Okay, so if you've received it, then it's outlined there, so it's not a deviation from those.
And it's specifically, word by word, almost, is what the firefighters' Bill of Rights requires.
There was some, I'd say some very productive wordsmithing, though, between the commission, our attorneys, and people who are, expert in this. And so it was looked at, and I think every effort was made to comply with the statute as well as our charter. And I think it's as best as we could do at the time. So hopefully it's clear.
Firefighters approve it? Did they have the opportunity?
Oh, yeah.
You got
Again,
input
yes.
because they're the agents who are most
Absolutely.
affected by this
This
administrative
was
procedure.
subject to meet and confer. They understood fully.
So with that in mind, I would move or suggest or say approve number 7.
Yep.
Yes.
I think it's
Yes.
unanimous. 7 is approved. What's next, Mr. Dole? I think we have 2 more. Before we get to mine, I think mine will just be next meeting, unless if you guys want to just go another hour and just get it over with, so we can then move to the next step of actually getting this in front of the employee association.
Yes.
Is that okay? Listen,
Okay.
You don't have to have any
Let me
dinner.
let me ask my senior.
As long as the staff brings in dinner for everyone.
You're right, I can't eat dinner after 7 o'clock, so maybe not.
Yeah, well.
So I'm trying to
Okay,
watch my weight.
let's get this one over with, and then we'll talk about dinner for you guys.
There's
Mr.
no
Chair,
funds for dinner.
What's next?
Staff number 8 relates to transfer in lieu of layoff. And this, This came up a few years back in a discussion relating to people being transferred in lieu of layoff to another position. And this is something we've done over the course of several layoff processes in an effort really to save people from being separated completely, is to find another job somewhere in the organization and assigning them to that. And the rules provide for that. But there was some controversy about this, whether or not those who were being assigned in this capacity had the opportunity to say no, or decline that offered transfer, or just be given the official notice that this was an optional decision. So we actually received direction from the commission at the time, and I can't remember quite when this occurred. I believe it was around 2015, that next time there is a layoff, and hopefully that never happens, at least not for the remainder of my career, but next time there is a layoff, that we incorporate some process when they are noticed of the layoff, that they are informed that their acceptance of a transfer in this, according to this provision, would be optional, and that if they wanted to, they could decline the offered transfer. Additionally, we got direction that we wanted to make it clear to the employees that even if they take this accepted position in lieu of being laid off, that their name would still appear on a layoff list. And we're fine with that. I think it makes sense, and I think we just want to incorporate that into the rules.
That means that, my understanding is, if I'm not mistaken, that you will accept a transfer in lieu of a layoff to a different position, but your name will still stay at the layoff, just in case if they go back and they do a rehire, then you can actually go back to your old job.
Okay, that's a yes.
So you actually,
That's a
in
yes.
2 places, one in the layoff list, and the second one is maybe in a lower position or a different position while you're on the layoff list. So it's a bonus for the employee, actually.
If I could continue this discourse, with the bottom line being that this is one of those proposed regulations that should go out to our employee associations for comment. But currently, if in fact the city manager, who has the ultimate power, then directs that XYZ permanent or temporary employees in lieu of layoff be reassigned, currently, if that employee says, no, I do not want to go to DPW, for instance, from planning or community development, that employee subjects him or herself to discipline and possible termination for insubordination, or they just go back to being laid off.
They go back to being laid off. Yeah, there's no discipline or
so it's a directive. That's interesting. So it's in a sense, if with that answer, it means very little but change, because it still preserves or reserves for the employee the right to say, I don't want to go to that other department. I've had no experience other than the fact that I can do accounting.
I would lay this, Commissioner McCarley, in the category of once again clarifying the rule and making it clear. Right. And again, we got some good feedback from the commission on how we should do this next time it should occur, which we weren't quite doing in our layoff letter 2 or 3 years ago.
Unless if I hear otherwise, it seems like this is one that's going to be okay with everyone.
Yes.
Yes. Yeah. Next.
Okay, members of the commission, this has to do with reinstatements. I think the commission is seen, maybe 2-3 times a year. We have an employee who leaves the organization, and they're allowed a period of time with which to apply for reinstatement back to the old position and get themselves back on an eligibility list. And as the rules currently exist, this process, the employee makes a request. That request is reviewed by Human Resources to make sure they qualify and they met all the time constraints. Human Resources consults with the department that they previously worked at. The department either signs off and says, yes, we agree, we'd love to have this person back on our list, or we don't recommend it. And ultimately, whether they agree or not, the employee has the ability to come before the commission and request placement on a reinstatement list. The recommendation here, or the proposal from staff, is to look at the situation, and really the idea is not to take away a commission responsibility, but look at when we have a case where the employee makes the request, The city department, agrees that it would be beneficial to have this person reinstated. The HR department agrees that they all meet it, that we not require this to come before commission. I can't think of any reason why the commission would go against a reinstatement if all the parties involved, including the employee, the department, agree with it. But again, that's up to you as far as your consideration of that. But that's the intent of this. And
Right now, it appears very vanilla, acceptable, except for something that you indicated, and that is that, and perhaps please clarify my misunderstanding, that if an employee who had, for one reason or another, resigned and sought reinstatement, and his department head refused the application for reinstatement, according to some provision in these regs, that former employee has a right to appeal to the commission?
that's correct.
I don't see that.
The employee, the process right now says that any employee seeking reinstatement must come before the commission. The department has the opportunity to comment. In many cases, I'd say the majority of the department says, wonderful, we'd love to have this person back. They're experienced, but there are some cases when the department says, oh, we don't recommend this person come back. Either way, the employee has the right to, the employee comes before the commission seeking approval for that reinstatement. What I'm proposing here is, if everybody agrees that it's a great idea to bring this person back, that be handled administratively as opposed to having this come before the commission. So
I want to make a comment, and this is very irregular that I would make the comment before everyone else does, but I feel very strongly about this, so I'm going to make my comment about this because I was sitting in this dais when something happened, which makes me say that there's no way I want to vote for this. An employee wanted to go to Dubai as in the city attorney's office, with all due respect. I'm sorry I'm bringing this up. And they decided we're going to go ahead and keep this job open for a year until this employee goes to Dubai, sees if they like the job, and then the employee will just come back and get the job back. With the city attorney's office. And we said there's no way, you're basically leaving a job open for a year for that one employee to go and try out in Dubai and see if they like the weather in Dubai, and then they come back. If this process is not, if you don't have this process, then that job could be open. The HR won't usually have any problems because it's probably a good employee. The department head has already agreed that we will leave this job open for you for 1 year for you to go and try and come back. Meanwhile, another employee that should be actually appointed to that position is basically put on the sidelines and say, well, you can't have the job until a year passes, until whoever this person was, Joe, comes back from Dubai. One reason that I would say no is specifically because of that case. I would say there's no way I would agree unless if it takes us less than 15 minutes to review it, and if everyone agrees and there are no other circumstances, I would say there shouldn't be a problem. But the second reason that I want this to come in front of the commission is as follows. I think that an employee knowing that there is even a hint, even though it's a vanilla we rubber stamp everything, even if there's a hint that an employee would say, you know what, we still have to go to the Civil Service Commission. It's not a rubber stamp. We still have to go, and they might say no. That might give them pause before they actually go to a different city to do work. Because it's not a guarantee that when they come back, their department head says, don't worry, go and try this out for 6 months. We'll keep this open. And then after 6 months, when you come back, we'll just give you the job. That has to come in front of us. We basically review all of the factors, make sure that there's no one who was sitting on the sidelines waiting for this job, and then approve it. Again, this is a protection for employees who could be appointed to that position that currently for the 6 months they're not, or maybe they are and they're opening a brand new position for that employee. I really think that one checks and balance having to do with that one particular issue of employee knowing that at some point they have to come in front of the Civil Service Commission and ask for their job back might prevent some employees from leaving. And then again, my first comment in reference to just keeping a job open for a year until the employee goes outside and decides that they like or they don't dislike a job and then come back for that same job. if we don't have that protection, then we won't be able to ask those questions. So I would say no to this particular issue. Yes?
I had written down, I read it a few times, and then I wrote down, no, simple oversight by Civil Service Commission, why remove the oversight? I was driven by an experience I had here where someone did come before this body who had been a great employee of the city of Glendale, had moved out of the city and had worked elsewhere, and there were some rather moving circumstances, and he had now returned to this city, and the department head was here, was saying this person was great. There was nobody that was able to be so good as him, and we went in there and came out and we reinstated the person. My question is, when we talk about reinstatement, approval for reinstatement, what are the many, or is there only one scenario where someone seeks reinstatement? Is someone seeking reinstatement is generally a person who left the city employ and wants to be reemployed with the city?
That's correct.
And
Yeah,
then if they
someone
want to be,
resigns and
right,
they
so
change their mind.
if they want to be reemployed by the city, and having heard intently on Commissioner Devine's many sessions of questioning to make sure employee rights are protected, shouldn't we then at that point be looking to see if this person is seeking reinstatement, was the position open, how long was it open, was there an opportunity for a promotion from within the city of one who is a loyal employee of the city, of that department that is still working there, rather than saying the department thinks this person is great, this person is great, they agree among themselves, HR gives the blessing, and the person gets hired, and then somebody sitting there says, wait a minute, why didn't they make this position available for promotional, if not then open for the best candidate to come in? This seems like and I don't want to be casting stones in any direction, it seems like this could be subject to a nod and a wink, I suppose, hearing this Dubai scenario that I didn't know about. But nevertheless, I come back to where I started. No, because it's a simple oversight by the Civil Service Commission, and why remove the oversight? I'm always troubled when I hear suggestions that seem to take away oversight that is really minor in terms of inconvenience of time. Here it is, it's 7:02 p.m. Chair Abkarian said, let's go through the rest. I said, let's go through the rest. Jokingly, we talked about dinner. I don't see, not jokingly? Okay.
I don't think Commissioner Devine was joking.
So I don't know what the issue is about removing this simple oversight. It's at the rate we're going, maybe we won't need this commission. So I don't know. I would be opposed to it for that reason, for the fact that I see it as a simple oversight.
Okay, so hearing that, I think it's unanimous that this particular item
I
should
didn't hear
not be.
from Commissioner.
No, I agree.
Oh, you do?
He was nodding, so I just assumed. Okay, so item number 9 will not be moving forward as recommendations from staff to the employee associations. All right, now, what's your pleasure, commissioners? There's staff here, there's member of the association sitting here since 5 o'clock, so it's 2 or 3. Changes to the rules are not going to be imminent tomorrow, that we need to do something that's going to affect anything tomorrow. So if we just leave it for February, Commissioner Manoukian is going to be here, so he can make some comments for
That's fine.
a final run, so to speak.
But were there people in the audience that needed to be heard? If they did, we should.
I don't believe so. I think that
Any
You
issue.
can entertain it, I guess.
anyone that would like to speak, you're more than welcome to. I think that the understanding is we finish this, give it to the association, have them make comments on it and make some recommendation. Then it's going to come back to us anyways, and we're going to have another round at it anyways. So my recommendation would be, it's 7 o'clock. I don't have a problem, but I think that it's just time is, I don't want to just go through it just so we can go through it.
No, it's a good idea to have
It's my
Commissioner
recommendations.
Menuchyan as well, why not?
So we bring this back in the February meeting, and we basically go through the February meeting. Or, in the alternate, in the third Wednesday in January, we have another meeting and we finish it.
Fourth Wednesday.
Fourth Wednesday, I'm sorry.
What is the date of that? I don't know.
24th, I think, let's see.
17th, 24th. Yeah. Mr. Chair, I would move that we reconvene.
That would be fine with me.
I don't know if the room is available. Used to be, but I'm not sure if it got taken. Is there a way of checking
I'll give it a shot.
availability of the council chambers? And it's, GTV6 and
Public
Okay,
notice.
let's agree to this. If it's available, we'll do it on the 24th at 5 o'clock, the same location. If it's not available, then we'll do it the first meeting in February.
Which is usually when?
First, second Wednesday in February.
So I'm
be-
spending Valentine's Day?
it'll be Valentine's Day.
Is it Valentine's Day? Okay, then more of a reason why we should do it on 24th, so we don't have a meeting in February.
Unless we have one on the 21st of February.
Unless if we want to get a divorce or have some issues with our wives and loved ones, maybe we should reconsider
We may
having.
have business on the 14th, but not to this scale, so
Mr. Chair,
we may have
Mr.
to have that
Examiner,
meeting.
I'm surprised we don't have any other facilities that can accommodate our obligations to disseminate this via video around the city.
We can do 105 and
Yeah.
MSB.
Well, why don't we leave that to
We
the.
just have to check to see
Why don't
what's
you
available.
check, if this is available, this is preferable, if not, then we'll go to whatever location you tell us to. And then Matt, if we can maybe consolidate what's gonna come on the 14th, on the 24th, then we can
Good
just
idea.
cancel the 14th February meeting altogether, and the next meeting would be in March.
Mr. Chair, you recognize that I think we're focused on the diversity conversations within the police department, because that's a report back.
I know, that's in March, though, we said.
All right.
We
pushed
said
it
that was going to be in
Okay.
March.
Okay. Yeah,
There's also a matter that is going to be a closed matter, and I need to find out from staff those dates. It was so long ago that we set dates. Unless that matter got resolved somehow.
I don't know, I haven't heard.
Oh.
Yeah.
Still, the hearing is still,
Yes.
still on calendar.
Yeah,
Closed
I need
I
to
thought that was in March.
refresh those dates.
Didn't that
Yeah,
start in March?
I think it's March.
Nari, could you do me a favor and send the people who are in that hearing the dates one more time again? Because I think we all put it in our calendars, but it would be nice to actually get that email to us.
I carry a physical calendar. That's why I'm a little reluctant about the 24th, because I look at this and it's not transposed, and I have a real physical calendar, so I don't know where I am on the 24th. But my presence is not mandatory.
Oh, it's mandatory.
The date of the meeting and the location we can confer, and it wouldn't be a Brown Act violation for us to work with the chair in selecting an alternate date for a special meeting, and then working with staff in determining whether the items on the 14th could be moved to the
We can be made aware so we can say we're available
Yes,
or not.
so we can handle
Well, right
that.
now, could you please check your calendars by tomorrow and let us know if 24th, and I think the city should also check with Mr. Menuchyan and see if that date's available for his calendar as well, the 24th.
Okay, we'll look at that. If these council chambers are not available, would it be your desire to see if MSB
Well,
105 or 106?
Only that typically when council chambers is in use, it's because of another televised meeting, and we cannot conflict. It's council's direction to have these meetings live as best as we can unless there's some reason why it cannot be.
Let's investigate all those and get
Yeah,
back to us.
Commissioners, I believe I have an answer for you. The room will be busy starting at 6 o'clock.
What happened?
This room will be busy starting 6 p.m. So there is a short window of an hour, but I don't believe.
No, that's not gonna do it. And is it a televised meeting?
This is specifically for the council chambers. I'll check about the MSB room as well.
Is it going to be
Is it,
televised?
whatever it is it, what is that, 6 o'clock?
That would be. Let's see if I
Party?
can see it here.
And it doesn't have to be televised.
It's a special meeting.
Council.
Okay, why don't you check on that and let us know, please? And then, as our counsel said, agreeing to a date is not a brown-out violation, so we can go ahead and go back and forth on those dates.
Her point is well taken. When there's 2 meetings scheduled, GTV6 has a real problem, and we experienced that last month when Commissioner Manukian had to be at another meeting, and I don't know if any of you watched our meeting afterwards, but the camera work was not good. There was one camera at the back of the room, and there weren't the close-ups, and so you missed a lot. So
Of
what
our
they
own
did
meeting?
of our meeting, yes,
Oh.
because
Well, you want a close-up of Commissioner Gazarian?
I haven't watched those meetings, so I don't know what
There
they
are
look
just a couple more items on the agenda if you want to go through those quickly.
I'm sorry, I apologize, that's right. We're not done with this.
like. Table those.
People, okay, so what's next, Mr. Doyle?
go ahead.
Reports?
Oh, I'm sorry.
It's reports and information. The only item is the past 2 evaluations. I will say this is for the month of January. There are no second, no third notices. However, quite a high number of first notices. Not to make excuses, but I would attribute that to
Holidays?
holidays. A lot of people out the last 3 weeks prior to this meeting. Additionally, a lot of people are sick. I mean, the city is experiencing illnesses like the remainder of our society. So anyway, but again, several first notices, but no second and thirds. So.
What's next?
Civil Service Commission, staff comments?
I just want to make a quick comment. As a new chairperson, I would like to make 2 understandings. We know that Civil Service Commission is not a rubber stamp. I mean, hopefully it isn't. That's not why we're not wasting our time. So a request by a commissioner for a report, I hope is well respected and is provided to us on a timely basis. And I hope that same respect comes from the department heads as well, which we've had all along. The same, with the same note, we also need to respect the efforts of the employees in the city and make sure that we know our position, know their position, know where each person stands. This way there are no hurt feelings and hard feelings. So I hope both sides will understand our job is only to request information to make this process fair. And the employee's job are to provide that, understanding that they're not our servants, they're employees of the city of Glendale that work for the city to provide us with the information. With that said, anyone else have any comments?
I have 2, with the concurrence of at least one of my colleagues, I'd like to ask for 2 reports to come back to this commission. The first one has to do with our investigation parameters. The charter, as we know, says we have the right to investigate. Some time ago, many years ago, a report was written by the city attorney's office which laid those out and said what we could or couldn't do. And I'm not sure that those are still valid or up to date. So I would ask that we have a staff bring back a report that revisits that again and lets us know just what we can and can't do in terms of conducting independent investigations. So that would be one, if somebody would.
I would agree to that.
Okay.
I would agree, and even instruct our attorney to bring that back without the editorial from the previous report, because the previous report brought in so many issues. There were so many discussions. We have 4 meetings just talking about that particular report, that I would like to get a fresh look at this particular item. So if you don't mind, just set that report aside altogether and just bring us a fresh report as to what your findings are as to the rights of the Civil Service Commission, investigation rights of the Civil Service Commission.
Thank you.
And then the second?
The second is, we all have had requests from employees where they've contacted us personally to bring up an issue or they're concerned about something. And I, of course, have had that too. And the one thing I've learned over the years, when you say to them, well, you should really bring that up before the commission as a whole so we can look at it and act on it. And the answer I get is, we're afraid of retaliation. The R word is really prevalent out there. So I would like to request, again, with the concurrence of one of my colleagues, is to have staff prepare a report on what this commission can do to effectuate a format for employees to come before us on different issues in a closed session or in a atmosphere where they can be anonymous. And I discussed it very briefly with our attorney, Ms. Varpetian, and there are various things we have to look at, but I think that if we could have a report come back to at least lay out the parameters of accomplishing that goal of allowing employees to come before us in some method, let their ideas or concerns be heard, and then we take it up as a commission and decide where to go from that point. But to me, the main point in this whole report would be to allow or create a format for an employee to approach the commission in an anonymous way so there's no fear of retaliation.
I not only agree with you, Commissioner Devine, I'd ask that our attorney looks into the likelihood, the legality rather, of the following scenario, which happens quite a bit. I have been on this body now, I don't know, 5 years maybe, or 6 years, and people do come. When they do come, it is very frustrating. When somebody comes and says, I want to bring this to your attention, it is beyond frustrating because I say what you just suggested that you obviously say as well. Bring it to the commission. Well, then they don't show up here. But then later, I get hurt, and I am subject to remarks that I find somewhat offensive at times from the person, from the disgruntled civil service employee who says, I brought it to your attention, you did nothing. Well, those of you who know me know that, you know, I don't have any masters in this city. I have no interest in this city other than I live in it. I don't have any projects. I have nothing in this city. So all I want to do is I want to come and leave, and at the end of my service, I don't want a Superior Court judge to ever overrule anything I'm a part of here. If our attorney can tell us that if that were to occur again, that we as commissioners, individually of course, then have the ability to inform our chair or inform our chief examiner to have that subject matter, whatever it may have been, or that complaint, that informal complaint, be put on the agenda, and for us to have an ability to discuss it as an agendized item without revealing the identity. An incident that I recall my colleague, Commissioner McCarley, I always get it wrong, I'm so sorry. Commissioner McCarley was alluding to someone that I got the sense that perhaps you had been approached or you were aware of it through a third party, but yet you did not feel comfortable or appropriate to reveal an identity of a person. It was regarding an issue a few perhaps meetings ago. It's important because that perception that we are a rubber stamp is one that I loathe, because we are not. As long as I've been part of this commission, I have not had an incident or an experience where I felt we were a rubber stamp.
I absolutely support and incorporate everything that my fellow commissioners have indicated, and especially what you have put in place, and that is a request for information,
Investigative
report that would outline processes and procedures that we could employ to either investigate, perhaps adjudicate legitimate concerns of the employee. I would suggest that that's ultimately going to require additional work, rules and regulations of this particular Civil Service Commission. This is a big and significant topic. And I think one of the reasons it's so significant is within the city of Glendale, we do not have a mechanism such as an inspector general or an ombudsman who is sort of an independent party who is endowed with a certain amount of confidentiality, and an employee who feels he or she was discriminated against, can go to the ombudsman or the inspector general, state what his concerns are, her concerns, and then the inspector general would report to us, and then we can determine whether or not that's subject to an investigatory activity. Yeah, this is hugely significant.
And let's make sure that the direction to our attorney is clear.
Yeah.
Because we don't also want to have an anonymous person come in and say, this is what happened to me. And then we try to basically do what a civil service commission would do on investigating that particular issue without the actual manager or the city being able to defend themselves at that point. And then become an investigation. So what my understanding is, if there's an issue that's brought into a commissioner then could come in and request a general discussion on that matter and request report on that particular issue, not specifically talking about that particular individual. So you can generally say, if this person says, I'm being discriminated against, you can say, could we look at the rules and regulations to see discrimination of this nature is valid in the industry. So this way we're not specifically talking about that employee. So if that employee wants to appeal it, then we don't actually have to recuse all of ourselves from that process.
Mr. Chair, to go way out on a limb and indicating that I should really be more gainfully employed, I am suggesting that the chair appoint sort of a subcommittee to begin that sort of process of developing these new rules and regulations that would incorporate what both of you have suggested. And I volunteer to serve on that
Okay,
subcommittee,
so-
which means I begin the drafting process of the rules and regulations.
If I can just interrupt, this is the the commissioner comment
exactly.
period.
Yeah.
Exactly.
We're requesting for
an information.
For information.
We are not going to discuss
This is
anything else
not
that
the
would be a
time to do
ground
that.
of
So
violation.
we will bring that
Thank you,
report
thank
back.
you.
I think we've received adequate direction.
This is-
We'll
This is
talk
why
with,
we have an attorney with us in here, and we
You
need
read
to
my
listen
mind.
to this. This is why we need to listen to our attorney to make sure that we're not really crossing some lines that we shouldn't be crossing.
Okay.
So you have directions, on those two items. I
got it.
think it's a report that probably will be brought back to us, I'm assuming in April, because March is going to be the
Hearings.
police hearing and stuff. March, I'll be also gonna have hearings, so it will probably come back in April. Would that be sufficient
That's fine.
time? Because our attorney would need enough time to be able to
Absolutely.
investigate those, and
sounds good.
very, very important, extremely important subjects. Okay, anyone else?
Mr. Chair, if
Yes.
I may, I want to thank you for the dialogue relative to the rules. I thought we engaged in a really good discussion. I think everyone truly read the report and did a lot of research, particularly the chair. But I do appreciate the discussion and look forward to continuing on. I think we make some progress on this matter. So thank you.
I think Commissioner Gazarian had a comment.
I'd like to make the final comment by congratulating you commissioners on your new roles. I look forward to a year of lively discussion on this body. Thank you.
Okay, thank you very much. What's next?
Adjournment.
I think.
Move to adjourn.